Imagine this scene. It's August 5th, 2025. The state is carrying out a sentence, and you hear a man on a gurney say, "It's hurting so bad." This wasn't some medical emergency in a hospital. It was an execution. Byron Black, a 68-year-old Tennessee death row inmate, was executed by lethal injection. And witnesses. They reported really clear signs of distress. Audible sighs, groans, and yeah, those harrowing words. It's stark, deeply unsettling, and it throws us right into a huge ethical dilemma. So today we're going to do a deep dive into exactly that dilemma. We're looking at the complex, often really troubling intersection where core medical ethics meet capital punishment. And also the broader challenges of end-of-life care inside prisons. How do people trained to heal, sworn to do no harm, handle state orders that seem to pull them into state-sanctioned death? Our mission here is to unpack the ethical stances of major medical groups like the AMA and ANA. We'll use recent real cases like Byron Black's to show what these principles look like in practice, and hopefully help you understand the challenges, the nuances when medical integrity bumps up against state authority. We've looked at the AMA Code of Ethics, ANA statements, news reports, trying to bring these abstract debates to life. So let's start there. That core principle, do no harm. How does that actually work for a doctor in this kind of, incredibly difficult situation? Primum non nocere.
Right. And it's an ancient idea, really. Goes way back. What's fascinating is just how deep this runs. The Hippocratic Oath, from ancient Greece, it's historically been read as clearly saying physicians shouldn't be involved in executions. It specifically states, "I will not give a lethal drug to anyone if I am asked, nor will I advise such a plan." So this isn't just some dusty old text. It's a living principle for major medical organizations today. It really underpins the whole identity of being a healer.
Ah, okay. And that's why groups like the American Medical Association and the AMA and the American Nurses Association, the ANA, they generally oppose their members getting involved.
Exactly.
In fact, I think the ANA just updated their position in 2024, right, to oppose both capital punishment itself and any nurse participation. They emphasized human dignity. That feels like a big statement.
It is a very powerful stance. And the AMA, well, they go even further. They define participation really broadly. It's not just, say, pushing the plunger on the syringe. It includes any action that would directly cause death or help cause death, or even things that could sort of automatically lead to an execution happening. It's a very wide net designed to protect the profession's integrity.
So it's definitely not just about, like you said, pushing the plunger or flipping a switch. What kinds of specific things are doctors or nurses told not to do?
Well, the list is quite specific. Prohibited actions include things like finding the right spot for an injection, starting the IV line specifically for the lethal drugs, prescribing or actually giving the execution drugs, obviously, but also monitoring vital signs during the execution, or even just offering technical advice on how to, do it properly.
Wow. So even advice is off limits.
The core idea is to stop medical skills or tools being turned on their head, used to end life instead of saving it.
That makes a lot of sense. I mean, using IVs, drugs, things meant for healing. Using them for execution just feels wrong. It twists their purpose completely.
It creates what ethicists call a conceptual contradiction, both for society watching and within medicine itself. Think about it. Can a profession that's all about healing keep its moral authority, keep the public's trust, if its tools and know-how are used by the state to kill?
Yeah, that's a heavy question.
It really forces us to ask if the value medicine places on life can truly coexist with the state's power to end it. And that tension, it definitely affects how people see doctors and nurses.
Hearing how broad those definitions are, it really makes you think about specific situations where these lines must get incredibly blurry, incredibly sharp. Is there a recent case that really highlights this ethical tightrope?
Absolutely. And the Byron Black case we mentioned at the start is a powerful and very recent example. He was a 68-year-old inmate on Tennessee's death row. He had several serious issues: a severe intellectual disability, dementia, congestive heart failure, and crucially, he had an implanted cardiac device, a pacemaker defibrillator.
Okay, and the issue there was his lawyers argued that if they executed him without turning that device off, it could shock him during the lethal injection.
Exactly. That it could deliver painful electric shocks, leading to what they called a torturous and prolonged death.
Which would violate the Eighth Amendment, the one against cruel and unusual punishment.
Precisely. And initially, a trial court judge actually agreed, ordered the device to be deactivated.
Oh, wow.
But then the Tennessee Supreme Court stepped in quickly and overturned that decision. They said the lower court didn't have the authority.
So the legal back and forth, and then the hospital that managed his care at Nashville General, they weighed in too. What did they say?
They did. And this brings in the whole institutional ethics angle. Nashville General Hospital stated, very publicly, that they had not agreed to deactivate the device. Their spokesperson said the request was, quote, well outside of that agreement, and that it would need help from other entities who were also unwilling.
So the hospital itself was reflecting that medical ethics stance, refusing to take an action that directly helps an execution proceed.
Yes, it perfectly mirrors those AMA definitions we talked about, refusing to participate.
But despite all these concerns, the legal fight, the hospital's position, Black was still executed August 5th, 2025. And just as the lawyers worried about, witnesses reported those clear, audible signs of distress. The groaning, him saying it's hurting so bad for several minutes. That's just incredibly hard to even picture. It makes you really question what a humane execution could possibly mean if someone is clearly suffering like that.
It really does. And the fact that Black, who had an intellectual disability, was showing such clear distress, even speaking about the pain, it directly challenges the state's usual claim that the drug, pentobarbital in this case, would quickly make him unconscious and unable to feel pain.
Right.
It just throws that whole ethical quandary into sharp relief, doesn't it? When a procedure meant to be, quote, humane, results in obvious suffering. And remember, his intellectual disability claim itself got stuck in this kind of legal limbo, a constitutional catch-22, even though experts agreed he qualified.
What does that mean exactly? A constitutional catch-22, that sounds like a terrible bind.
It is. Devastatingly so in this context. It basically means the legal rules for proving intellectual disability were set up in a way maybe contradictorily or just incredibly strictly, that even with experts saying, yes, he meets the criteria, his legal claim couldn't get past the procedural roadblocks to actually stop the execution.
So the process itself kind of overrode the substance of the claim.
In effect, yes. It's a tragic example of how legal processes can sometimes obscure the fundamental human reality. And it's moments like these, difficult as they are, that show why medical professionals often feel such a deep moral conflict. Their whole training is about easing suffering, not causing it.
And this ethical tightrope, it doesn't just apply to the moment of execution, does it? It broadens out to general end-of-life care for all prisoners. That seems like another whole layer of challenges. Cases like Brian Rigsby in Alabama dying of liver failure without his mom there. Or Adam Spurgeon in Tennessee dying after heart surgery complications, also with limited family contact. These point to bigger system issues.
They absolutely do. People who are incarcerated often have very little control over their end-of-life decisions. What's really striking is how security concerns can often trump patient autonomy. Correctional officers might override patient wishes. Even sometimes DNR orders do not resuscitate order.
They can override a DNR.
It happens. Some ethicists have actually called the federal policy of forcing CPR on patients against their documented wishes cruel, even the inversion of the death penalty.
Wow. Forcing someone to endure treatment they don't want.
Imagine being forced to prolong suffering against your will in a place where you already have no freedom. It's a profound violation of autonomy.
Just heartbreaking. And Brian Rigsby's mother, Pamela Moser, she couldn't even visit or speak to her son while he was dying in the prison infirmary. It really underscores that our prisons just weren't built for complex, compassionate end-of-life care. Their focus is, well, custody and security.
Exactly. And that brings us to an important clarification about what doctors can do. While they absolutely must not participate in executions, they are ethically allowed, even required, to give medical care to condemned prisoners. But only for healing, for comfort, or to preserve life.
Okay.
So that could mean treating something like appendicitis, managing diabetes, or even giving tranquilizers to ease anxiety or pain, but only if the prisoner voluntarily asks for it while waiting for execution.
So the key is the purpose. Care for the person's life and well-being, not care to facilitate their death.
Precisely. That distinction is critical for maintaining the profession's integrity.
Even certifying the death is okay, but only after someone else has officially declared the person dead, right?
That's correct. It keeps the physician separate from the act of causing death.
And what about something like organ donation? Is that ever permissible from someone on death row?
It is, yes, but under very, very strict ethical rules to avoid any sense of, complicity. The decision to donate organs has to have been made before the person was even convicted.
Oh, way before.
Yes, and critically, doctors cannot advise changing the execution method in any way to make organ retrieval easier or more successful. Again, it's about drawing a very clear line. The medical act must be totally separate from the state's act of execution.
So what we've seen in this deep dive today is this really profound clash, isn't it? You have the medical profession's core commitment, heal, do no harm, standing firm against state actions that seem to demand involvement in ending a life. And it's not just one or two groups. It's a broad consensus across major medical bodies. They're saying our professional integrity and the public's trust in us depends on keeping this line clear.
Absolutely. And cases like Byron Black's or Brian Rigsby's or Adam Spurgeon's, they aren't just abstract ethical puzzles. They show the real human impact when these lines get tested. They underscore why sticking to these professional boundaries is so incredibly important for medicine's soul, really.
So for you, our listeners, in a society that tries to balance justice with human dignity, it leaves us with a tough question to think about. How do we reconcile the state's power to impose the ultimate penalty with the medical profession's fundamental duty to ease suffering even for the condemned, without forcing doctors and nurses to betray their core ethics? What part of this deep dive stands out most to you?